Okay, let's start this new panel. As people come in, if someone can close the doors, please, at the back. So this panel builds very much on the conversation we just had, which is about posture, is about gaps, is about outcomes. And so the conversation, I have 5 great enforcers on my sides. I think what we want to discuss is a bit what the current view is in terms of gaps in the specific jurisdictions, what you are doing, where this assessment is sort of coming from, and any early signs of success or bottlenecks in terms of this approach. So I want to start with the US side and then move to Europe. So if I can start with you, Rebecca, and the FTC. We've heard from John. Obviously, you are, as a commission, you believe there are gaps, and you're trying to help in terms of outcomes. You're working with other parts of government. You're doing a number of things yourself. So it would be very useful for us as a European audience just to have a bit of a sense of what you've been doing in the last year or so and your assessment of that.
Thanks, and it really is such a pleasure to be here with so many distinguished colleagues and so many impressive people in the audience. Let me start by saying I don't think we intentionally lined up to put the US on one side and Europe on the other, because I think there is a lot of convergence in how we are thinking about things and working on similar problems, albeit with different tools. I think I'm gonna answer your question, Andrea, with some specific examples, but I want to start by a framing theme. When I was listening to Rana speak this morning about connecting dots, that really resonated with me because I think it is very much at the heart of what we are doing at the FTC in 2 specific ways. The first, I would say, is we are connecting the dots with how people participate in the economy as whole people. And that is a really important thing. Rather than just looking at consumers as automatonic end users, we are understanding that people are whole people who participate in the economy as consumers, as users, as workers, as small business owners, as patients in the healthcare system. And all of these roles are related to each other, and our approach to them has to be related. And the centering of whole people, to me, is very important because at the end of the day, who do we as government officials serve? We serve people. The US government serves the American people. We do not serve the antitrust bar. We do not serve expensive consultants. We don't serve industries in and of themselves because we are serving the American people. And so understanding the way our work affects them is really important. And that leads me to my second dot connection point, which is we are working very hard to connect dots Tim talked about throughout the US government with the Biden government's whole of government competition approach. But within the FTC, that's an important approach too. We have a competition mission and a consumer protection mission, and these have historically been treated as very, very siloed. It was actually one of the things that surprised me the most when I got to the FTC was how incredibly distinct the 2 sides of the house were operating, when in fact I think there are huge ramifications for the way the work we do in each area affects the other. So when I want to focus in plugging gaps is a few specific ways we are doing that dot connecting across the agency. The first one I want to talk about is our non-compete rulemaking that we launched I've lost track of months. It's now March, in January. We launched it in January, building on some cases that we also did. I think this is one of the most important things that we can pay attention to that will affect real people's lives. And this is connected to what Christina and others were talking about this morning about antitrust historically being this very complicated, way above the heads of real people. It's not. Competition matters to real people in their everyday lives, and there's almost no way in which that is more true than in your ability to leave the job you don't like and get a better job based on merit, and your ability to compete for those better jobs, and the necessity of companies competing for your labor. And the problem with a clause that is literally called non-compete. I mean, that should be a huge red flag to anyone who cares about competition policy. So that's one thing, and I think that it deals with sort of people's whole lives and how they approach the world. Right to repair is another project that we've been talking about a lot. This is another, one of the most frustrating things for people is you buy something really expensive and then it turns into a brick. And that's true whether it's your phone or your tractor, if you're a small business, your ice cream machine, whatever it is. Understanding the problems with repair restrictions through both a competition lens and a consumer protection lens activates tools that I think we have historically not used. A couple other things I'll mention. We are doing in the middle of a big data security and commercial surveillance rulemaking effort. This is nominally, it is actually under our Unfair and Deceptive Acts and Practices Authority, which is our consumer protection mission, but how companies use data, collect, use, amass, keep data has enormous competition implications. And so making sure we're looking at these things across the mission areas is really important. And the last one I think I will mention is, just last week, Amazon closed its acquisition of One Medical, which is a healthcare practice. And you read a lot in the newspaper right now about disagreement and discord at the Federal Trade Commission, but you might not have read that we put out a unanimous statement last week, all 4 commissioners, sitting commissioners on a statement, that talked about the fact that this transaction may raise very serious privacy risks. It's a competition question initially presented to us by a merger, but we have to think about what does it mean for the other laws that we enforce too. And all of the commissioners on a bipartisan basis agree that this is an important thing for us to be looking at. So fundamentally, I think this goes back to a theme that we heard from Barry and others this morning, which is what are the laws that we have? How can we use them as they were written, rather than imposing our own self-imposed limiting principles on them, but actually giving meaning to the intent of Congress to really make sure that the markets that we look at are serving the people that we also serve. So those are just a few examples. There are many, many more. John talked about some of them too, but there are many other people to hear from this morning.
Thanks a lot. Can I just ask you a quick question? In terms of the role of the courts and litigation in this area, how does it work when you try to, use things you haven't, a bit what John was saying, so we understand that in the context of mergers, but in the context of rulemaking, what's the kind of judicial oversight of that? And do you have any sense at this stage of how tough?
Yeah, there's a very healthy industry dedicated to suing the FTC, and I think we anticipate that basically everything we do may result in a lawsuit. That's probably because the things we are doing are effective and threaten incumbents' existing business models. So I take that as a given. My mantra is always you have to do the right thing in the right way for the right reasons, and we have to look at the law, figure out what our obligation is, what is both the statute and the jurisprudence say, and what is the argument we're going to make to a court. And then we will inevitably have to bring those cases to court. Practically, in terms of rulemaking, what happens is I think we would have to get to a final rule for anyone to have standing to sue us, but then I assume that we would have some aggrieved party bring a lawsuit challenging our rules, both under whatever legal theory they come up with, maybe the substance of the rule, maybe the authority to issue the rule, but I think these are not surprises to us. And so we will be well prepared to argue why we think we are doing the right thing under the law and with the jurisprudence that we have.
Great, thanks a lot, Rebecca. Doha, so on the DOJ side, obviously you and Jonathan have also been plugging gaps and working in a number of areas. So again, it would be very useful to get a sense of some of the most recent things you've been doing.
For sure. Again, thank you for having me. You're going to hear a lot of similar themes, I think, from me and Becca. One thing I would like to do before we get into the substance of actual gap plugging is to talk a little bit about context, right? How we got here and why this particular moment in antitrust matters. And you'll have to forgive me, I was a history teacher before I went to law school, so I always revert to history. In the United States, we are quite actually a people born out of revolution, right? People who overthrew a monarchy, and I think that it is a distinct quality of Americanism that we don't like being told what to do, right? We value democracy, we value choice, and it is not a surprise then that in the legislative history of the Sherman Act, our first antitrust law, that we talk about how Senator Sherman talks about how if we wouldn't have a tyrant, right, in our form of government, that we shouldn't tolerate basically robber barons, right, like the tyrants of industry. And so, I feel like I've had a front row seat to a revival in the United States. And I think there are debates about the causes of it, but recall that almost 15 years ago now, we had the financial crisis, and I think Americans witnessed some things about wealth transfers and opportunities that were available to them. We saw a lag in the recoveries, right? There was like this two-headed recovery. Some people are worse off than they were, and some people recovered quite quickly. There was reduced labor dynamism, right? There's a growing body of economic research about reduced labor share of GDP. And then there's, of course, the massive demand-side market failure that was brought by the pandemic. And I think, 2016, we had an election, and I think that there were some populist forces that took hold on the right, and I think there were similar populist forces that took hold on the left, and it would be ahistorical to try to separate the reasons for those, outcomes. And so, at the same time, you have different kinds of economists doing more research about labor markets in particular. And again, I feel like I had a front row seat to this. I had the great privilege of being the division's special counsel for labor and thinking about how we can do more in labor markets and how that's an important dimension of the industrial relations of firms. And so what was very clear to me, I think what's clear to Jonathan and the rest of us at the division, is that Americans are not unclear about the impact of competition in their daily lives, right? And so if you view antitrust as technocratic, as coming from the most erudite people and flowing down, you are likely to miss it, and there will be misalignment between us and the people that we serve, as Becca noted. And so Americans are aware of what happens when they go to the doctor, when it takes months and months to go get care that they need, when a private equity firm or some other kind of buyer acquires your company and things change at work, when grocery store prices rise. And I think that for all policymakers, law enforcers, including us, we are necessarily reactive and having to be responsive to the issues of our time. And for better or for worse, these are the issues of our time. And so in terms of competition, what does that mean as a practical matter? It means that we have reassessed, we're in the process of reassessing how markets actually operate. I think that we had intuitions, notions of how markets operated. And I think we are reevaluating some of those intuitions. We're thinking about how competition actually presents itself. We're thinking about the tools that we can bring to bear on mergers, thinking about the tools that we can bring to bear on certain kinds of business conduct. I've mentioned labor already, plugging gaps, enforcing the law as it's written. Revitalizing criminal Section 2 enforcement, right? Section 2, our monopolization statute, is actually a felony statute in the United States, and we've had recent enforcement in that area. Recently, I gave a speech in Miami about information sharing. When I first got to the agency, I think there were notions about how information sharing could be sustained and nurtured, right? You need maybe oligopolistic market structures. And what I think we're finding is that very diffuse markets can nonetheless sustain remarkable amounts of information sharing that give rise to competition concerns, and so we're reevaluating that. I think there's been a lot of ink spilled and a lot of discussion about the power of data, but certainly knowing the power of machine learning and AI, we are thinking about really what is the value of old data. Again, we have these intuitions that very old data is maybe not that useful. When it's non-rivalrous, it's not that useful. And I think, again, we're rethinking that. So we'll have plenty of opportunities to talk about gap plugging, but I thought it was important to at least lay that foundation in context.
No, super interesting. Thank you. Just one quick question. I mean, you obviously litigate cases. That's the way you achieve outcomes in the division. And so you and Jonathan spend a lot of time thinking about sort of litigation strategy. I mean, what's your, I mean, in terms of, I mean, certainly has been my experience when I was at the CMA, we always struggle a bit with the courts in a sense, there's this internal dialogue, this, we spend a lot of time with stakeholders understanding these issues, but then the actual dynamics of litigation hasn't really changed much from what we could have had 5-10 years ago. I mean, what are you, are you bringing in more narrative, more history, trying to get the judges to relate more with the kind of reality of these cases?
Yeah, look, storytelling in litigation is really important. The division has won some cases, we've lost some cases, and I think we're adapting our approach to how we tell stories about market power. I also think that, while the judiciary in some cases can be very quick to understand our competition concerns, and in other cases maybe doesn't find in favor of the agencies, I think some of that is due to the lack of enforcement itself. The narrative content of the antitrust laws in our case law, I think, suffers from serious gaps precisely because we haven't enforced up to the levels that I think we should have. And so part of our task here is to make sure that there's a rich, steady sort of diet of cases and that we're giving judges opportunities to really engage with facts and law. And so I'm really very excited about that. I think we've already broken numerous records for cases that we filed, and it's not going to slow down anytime soon.
Yeah, no, great. Makes a lot of sense. Benoit, so obviously the sense of urgency on the US side, and certainly quite a lot of change from what the previous administration was saying in the US. I mean, again, you've been now in antitrust for a couple of years from a different world of policymaking. I mean, where are you on these issues about outcomes, working with the rest of government in France, gaps, and what you're doing with that?
Yeah, thank you for having me here in this fantastic conference. There ought to be a sense of urgency everywhere because for many reasons which have been already outlined, but one of them being that the economy around us is changing very fast, and it's not changing more slowly in Europe than in the US. It's changing for the same reasons. I think it's hard to underestimate the amount of change we're going to see in our economies in the next, I would like to say in the next decade, but it's really going to be in the next years, if not months, with a lot of disruption coming from digital, obviously, which I think will be a kind of underlying theme in our discussion, but it's itself changing very fast. You see the importance of AI arising very fast, and I guess we're all asking ourselves questions about the way AI is changing already under our eyes search engines and how we should be dealing with that. We had this big copyright case last year related to the way Google was remunerating publishers, or actually not remunerating publishers. That was the issue initially, and so copyrights in the ChatGPT world. I mean, that's going to be also an issue for us, and I wouldn't dare to pass a judgment today because it's too early. But that's coming very fast on the agenda. So lots of change coming from digital. Lots of change coming from the climate transition, decarbonation, etc., which we have to understand before we can act. and also lots of political change, lots of fragmentation in the global economy. So it's not deglobalization, but it's certainly not globalization as we knew it. We see a lot of fragmentation, which will have an impact on market dynamics, and which would create a lot of local market power in areas where, in industries where we wanted to have increasingly a global approach. So that's all kind of the ground is shifting below our feet, under our feet, and we've got to be fast. So the waters will be very choppy, and if I make kind of abuse of this metaphor, that kind of leads me to three conclusions. First, we have to know how to navigate the waters. We've got to know how to chart the waters, and we've got to know how to keep afloat, right? And let me explain. Navigating the water, that means that we need to be agile, we need to be fast, so it's about the mix of instruments that we have. We've been, as everyone knows here, we've been endowed in Europe with new instruments by the ECN Plus directive. We're still kind of testing and trying with some of these, but we need to be fast to understand how we can use them and to give clarity to the industry. And it's about using a mix of instruments. So in recent digital cases, we've been using a mix of commitments, settlements, interim measures, and fines. And so it's really more an art than a science to know how to combine all these instruments. I mean, there is no general answer to that. It depends very much on the cases, and we're still learning with it. But I think the kind of tentative conclusion is that since we'll have to be faster in some areas, we're going to use more interim measures. We are going to use more settlements, but we also have to be mindful of the shortcomings. And just to illustrate, commitments in digital or in any other industry, that's something that allows you to keep the business running. That's certainly something that the rest of the industry likes, because it can help keep the industry running and even bring back into the industry players which had been foreclosed by the dominant players, and that has an economic value. But on the other hand, as an agency, it brings you closer from becoming a regulator, no? Because you've got to negotiate all these commitments. So you've got to go into all the fine machinery of what's going on in industry X or Y, and this is generally not our line of business, to be an industry regulator. And it changes the culture, it makes you kind of come closer to the industry. You need to have a cozier relationship with the industry because you see them all the time and so on. And that might not be a place where we want to be as enforcers. We want to keep some distance. So that's just an example of the, it's not so easy to decide on what's the right instrument. That was about navigating the waters, but then if you want to navigate the waters, you need to chart the waters. So you need to know where you want to go, and you need to understand the kind of structural change that is going on in the industry. And that's not so easy. So for instance, when it comes to sustainability or decarbonation, we've spent an awful lot of time in Europe discussing sustainability agreements, exemptions under 1013 or under the farming regulations, the industry organization exemptions. Well, that's all fine, and we're going to do that, right? We're going to identify cases and so on. It's very important. But what is even more important is to understand how decarbonation is going to change the industry. We know very little about that. So we've recently launched two market studies, one into transports, local transports generally, including intermodality, interoperability between local transports, also with this sustainability objective in mind. We've launched another market study into docks for electric cars, which is an incredibly important market if you want the industry to decarbonate. We want to know more about car data, obviously industry data, and so on. So that needs a lot of analytical resources if you want to understand what's going on. And in many cases, it will be more efficient to do it jointly with colleagues, with the European Commission, in the OECD, in the ICN, and so on. We need to join forces because it's such an intellectual investment. And finally, you need to survive and stay afloat. And what I mean by that is we're not going to be in a friendly environment. Politicians want they want industrial policy. It's all about sovereignty. It's all about it's all about local buying European, buying American, buying Japanese, and so on. Competition is not fashionable at all. Well, it is in this room, but it's not in the outside world. And so we've got to we'll have to be to double down on the education effort, and on the outreach, to explain people why what we're doing is so important. And we had a notion of that listening also to Rebecca and to Dora, and they're doing it a lot. We might have to do it more in Europe to explain citizens, to explain people with examples they can relate to why competition is important. Otherwise, we'll lose the battle. I think I can stop here, but that
yeah, just a very quick question on this point. I mean, in terms of the debate in France, and obviously we had very high inflation all of a sudden over the last 18 months. I mean, what has come your way as an agency in terms of in terms of the debate? Is there a sense that competition is important, and if you don't have enough competition, that's one of the components of high inflation? Has it helped in terms of you describing the importance of competition, or in a sense has been just about energy, the war, and about other issues, and hasn't really touched your agency?
No, it does help. It does help to be, and I hate to be saying that, but it does help to be in an environment of high inflation, because it helps explain people why lower prices are important. And in Europe, we've been for the last 10 years in an environment of very low inflation, where consumer welfare was very difficult to explain. I mean, diversity is always easy to explain, but prices weren't an issue in most places in Europe for the last 10 years, and now they are. So it does help, and it also kind of makes you understand that what really helps you relate to people and explain people why competition is important. It's not all the shiny new objects that we have on our table, interim measures in the digital sector and all that. That's a fascinating discussion for all of us in this room, and it's also very important in some industries. But what helps you explain people why competition is important is the jam cartel, the ham cartel, the concrete cartel. It's our traditional line of business, and that which people understand very well. And so we should keep invested in busting cartels and detecting anti-competitive practices in industries that matter for the daily lives of people, and that's also important for prioritization of resources.
Great, thanks a lot, Benoit. Margarita, you're coming to the end of a very successful term. Well done. Your thoughts on this issue in terms of your experience in Portugal and just looking at the European landscape in terms of your reflections. If you think about what you have done in the last few years, where you are now, sort of gaps, things that you have tried, and a bit your reaction to the kind of change dynamics in the US over the last couple of years.
Well, I think it's fair to say that what I've heard, not just in this panel, but before that plugging the gaps requires a lot of determination, a lot of attitude, not necessarily changing the law, but a lot of attitude, a lot of determination. And I think the first gap I saw over the past few years that needed to be plugged was enforcement, more enforcement, better enforcement, faster enforcement, and we did our best. But I think we can agree that all of us here that enforce only uncover a little bit of the infringements, a small fraction of the infringements. There's always a lot more to be done. Another thing that so strong enforcement generates more enforcement, actually, because you start getting a lot more leniency requests. And certainly for us, last year was the peak, an all-time high in our leniency requests, 9 leniency requests, of which one was a summary one. But in any case, all-time high because of a stronger enforcement. Now, another gap that I saw needed to be plugged was also the fact that as enforcers, we should not shy away from the less typical cases or less navigated seas, such as labor markets, such as hub and spoke cartels. And so we did not shy away when we found them. And we actually prepared a lot of that work beforehand, especially in labor markets, which were virtually untapped. I don't know why, but you know, there was certainly a problem there, and there was certainly an opportunity there, especially during COVID and post-COVID, where people needed to be freer in looking for another job, a different job, changing their careers.
Sorry, can I just ask you a quick
Sure.
question on this point? I mean, did it come to you as a complaint from someone, these issues in labor market, or was it your own sort of investigation and self-assessment?
Certainly, I identified it as a problem in the market, but we did some previous work in order to understand what had been done academically and what had been done in terms of enforcement, and that was more the case in the US than in Europe. And then while we were doing it, and we were publicly telling companies and other policymakers that we were doing that work, we came across a case that we read in the press. It was actually announced, a case of no poach that was announced in the press. And while we were still going through our research work, we went forward with the case. But once we finished our let's say, research work, and we publicized it, it got a lot of attention, and we received tip-offs and even leniency requests, so that we now have a very interesting pipeline of cases that we're pursuing in no poach. But if I may go back to plugging the gaps, I think it's also important to be relevant and timely and pertinent to our citizens, to our consumers, but also to the firms that abide by the rules. And so once we see in our risk-benefit analysis, and I say risk because there are moments in time in which you have a really big risk. So for example, and we shouldn't shy away from looking carefully into those areas in which we see higher risks. For example, during the pandemic, there was obviously a higher risk for crisis cartels. And I say crisis cartels not just in the classic sense, I say in a much broader sense. Cartels that take advantage of the moment in time in order to raise prices even more than they could already be and take advantage as much as possible to their benefit and not to the benefit of consumers. And so we started looking very early on in 2020, 2021 to, for example, the health sector. And that yielded results because we started investigating cases in the health sector, namely all sorts of blood tests and COVID testing as well, which has already yielded an SO to that sector. But having in mind the very clear risk analysis, and then the benefits of pursuing some cases where the risks are higher, the benefits to consumers, allows us to be more pertinent and more timely. Then, I think one of the things that I'm happy that we've done over the years is also to be to issue opinions and to issue advice to government, to Parliament, where we see a need. And I go back to what Benoit was saying about inflation. Inflation was certainly a case where we saw that we needed to explain what we can do and what we cannot do in the short run, in the medium and long term, but also to inform governments or to give governments an informed opinion about what they should be doing in this particular moment in time. So, for example, in terms of inflation, trying to avoid price caps, trying to make an informed decision given the risks of setting price caps or other types of decisions, including in recovery plans, by the way, decisions that do not distort inflation, or at least that minimize that distortion in time. So I was happy about that, and that's also part of plugging the gaps. You know, making, giving opinion where it's needed right now in the current time. And then, if I may, finally, just to finish, and this is looking to the future, I think, and this is more legal, more of a legal gap than the rest. The rest was not legal. We had the tools to do that. I think it's international cooperation, and I think we've done a tremendous job in mergers. I think we've achieved a lot of international cooperation there. In terms of antitrust, I see areas such as the financial sector, corruption, anti-corruption, anti-money laundering, anti-tax evasion, having achieved a lot of results over the past 20 years. I don't see that yet in antitrust enforcement, and there's still what I would call safe havens for members of cartels or companies that abuse, and maybe that's something to tackle in the future.
Great, thanks a lot, Margarita. Martin, what's your view from the Netherlands in terms of plugging gaps and things you have been doing?
Yeah, thank you very much, Andrea. Thank you, Christina, for inviting me. I thought in preparing for the panel, you know, what are actually the gaps that we are working on at the moment? Which gaps are we plugging or in the process of plugging? And I identified 4 gaps. The first gap, horizontal consolidation by dominant companies. Second, tacit collusion, a word that I haven't heard so far in the discussion, which I think is an important topic. Exploitative abuse. And thirdly, the application of paragraph 3 of 101 means the legal exception to the cartel prohibition of paragraph 101. And I say this with, I think Tommaso was saying that he is an orthodox economist and a orthodox but progressive. I'm a lawyer by training, antitrust lawyer by training. I would qualify myself as well, orthodox and progressive. And heading an agency that has a wider mandate than just antitrust. And I just give you that as a realization for how we as an agency look at the world. So we are not only the antitrust enforcement agency, but we're also the energy regulator, the telecoms regulator, the consumer protection agency, and soon the digital regulator on the Digital Services Act. So we take this together as under a joint mission, and our joint mission is making markets work well for all people and businesses now and in the future. And the words that Rebecca mentioned about looking at people rather than consumers in their capacity as a human being is key to the way we look at markets, also from an antitrust perspective. So what are the four gaps? The first gap that we are now in the process of filling and that we're working on is our, I would say, opposition against already dominant companies acquiring actual or potential competitors, small or big. There's a lot of said in the past about killer acquisitions and the reasons why it is important to stop killer acquisitions. But I think a new phenomenon is arising in many countries around the world where mostly, but not exclusively, private equity companies have roll-up strategies where they slowly buy relatively small players in sometimes regional, local, sometimes national markets in order to gain market power in that geographical area. Lots of these transactions remain below the threshold of required merger filing. I think this is problem 1 that we need to fill. That's why, on a larger scale, we fully support the Commission's view on the Dutch clause and making sure that below the threshold mergers can be reviewed at a European level. And I think it would be good if all European countries have a similar system in their national jurisdictions as well. We don't. And this is something that might require or should require a change of the law. Second, what is important is what is the substantive test for these transactions. Now, of course, it is a significant effect on competition. The merger should have a significant negative effect on competition in order to be prohibited. But what is significant? We now have a case before the courts, which is going to be very interesting. It's a court of first instance, so we'll have to see what happened, where we prohibited a private equity-owned dominant company in the healthcare sector to acquire a very small competitor. The increment in market share was, really small. But we nevertheless said, yeah, but from a policy perspective, if you put the burden of significance too high, that actually would mean that a dominant company, by a roll-up strategy, could ultimately get a monopoly. Because each individual's transaction is not significant, but the entirety is significant. So this is something that we put before the court. Also the policy perspective we put before the court, and we're waiting the judgment of the court, I think, within the next few months. Second, tacit collusion. I think a lot has been said about dominance and monopolization, but tacit, any of our concentrated market is or can become a big problem. We as competition authority cannot do much against tacit collusion with our our regular equipment, but it is a problem both in upstream markets, think about labor, and in downstream markets, both in business to consumer markets and in business to business markets. So what to do about it? Obviously it doesn't make any sense to prohibit tacit collusion because it's not something that you can prohibit. But competition authorities and market authorities need the tools to make markets work again. So far, most competition authorities have very limited tools. The CMA has a tool in market studies instruments where it can impose remedies to make the market work again. Think about, for example, transparency obligations, if that would be of help, but also ease switching burdens, removing switching burdens, imposing interoperability or portability obligations on the companies to make new entry possible and to remove the threat or the actual occurrence of tacit collusion in the market. I think this is an area that needs to be explored in a wider sense. It is a pity that the European Commission's new competition tool is off the table again. It was replaced, and I fully understand how that happened with the Digital Markets Act, because that's where the the focus and the primary concern was. But I think it's now time to rethink the new competition tool, put the new competition tool on the table and see if that could work at the European level, but also at the national level, particularly against tacit collusion. Then the third gap is exploitative abuse. I studied antitrust law and exploitative abuse, unfair prices and unfair conditions was just part of, of the study. But something happened in the 90s and early 2000s. I think suddenly the economists joined the game and they thought unfair, we cannot do anything with unfairness. We want price effects. That's something that we can measure. Unfairness cannot be measured. And I think that's where we took the wrong turn. I'm not saying that we should go back to the old days, but I think we should dust off the unfairness in unfair abuses and unfair trading conditions by dominant companies and look at it again. And that requires a legal mind. And for the economists in the room, lawyers have talked about and thought about unfairness for ages. Before the time that economy was actually considered a science. Unfairness is a fundamental moral and legal value in our society. It has been since the beginning. And if you look at the old laws, fairness plays a keystone in the way we look at our societies, including our markets. So we started our Apple case in the online dating sphere on the basis of 102A, the exploitative abuse. And we're glad that other authorities, the German authority with the Facebook case, the French authority, and also now the European Commission, is taking on cases based on unfair trading conditions, as the commissioner told us earlier today in the Apple case. Yes, it is relatively uncharted waters before the courts, but that gives also an opportunity for the enforcers to find the right balance, to find an equitable solution against unfairness, where we put, people and businesses first and center of our enforcement actions. Finally, the legal exception to the cartel prohibition. I'm not a specialist in US antitrust law, so forgive me for suggesting that this paragraph 3 exception to the cartel prohibition is unique for Europe. Maybe it isn't, but I always thought it was unique. While 102A may be under-enforced, I think paragraph 3 could be over-enforced, in the sense that there is a serious threat or a serious belief among businesses and NGOs and consumer organizations that 1013, the exception, cannot be used. And that's why there's little practice with 1013, and that is a pity. Because it was also, coming back to something that I heard earlier, it's also our democratic duty to apply 1013. It is in the law. It's not for nothing that it's in the law. And why it is particularly relevant at the moment is that there are, many very complex supply chains that need to be changed in a relatively small period of time. We have food and agriculture, we have chemicals, we have energy, and transitions need to be made to a more sustainable supply chain in a relatively short period in order to avoid a climate disaster. Regulation is failing short of delivering results. And also, we as regulators, we as the government, do not want to micromanage the economy and micromanage the transition. And what can be helpful, or what is helpful, is that we use the structure and the rigor of 1013 to allow vertical and horizontal cooperation within the supply chains to move towards a more sustainable economy. And give you a very short example of the complexity of the issue by looking at my own country. So the Netherlands is a small country, a province in probably most of the countries where you're coming from, but we live together with 18 million people in a very small area. But we do this together with 100 million chicken, 12 million pigs, and 4 million cows. So this is the size of North Rhine-Westphalen in Germany, but with a lot of animals. We have a huge industry that's built around it. We import massively soy and corn from the US and South America. We feed it to the animals, and then we export the meat. Mostly to Germany, to Italy, but even to China. Dutch pig farmers are competitive with Chinese pig farmers. You don't have to be an economic wizard to think, well, here is something wrong. And yes, there is. Because there is a huge environmental problem in the Netherlands because of this entire industry. But at the same time, agriculture is part of our cultural identity. Wooden shoes, cheese, tulips, pigs, that's us. And therefore you see an enormous political support for the agricultural industry that wants to keep this industry alive. We need to change this. We cannot change this by imposing government regulation to change the agricultural sector. It's been tried, and the farmers block the roads, they block off government center, they just simply do not accept it, and they get the full support of the majority of the Netherlands people. So the only way to change these complex supply chains and give a future to the farmers who want to continue to farm if it's bottom up. So if we, together with the farmers, together with the industry, together with the retailers, find new business models for these farmers in a short period of time. And that's why we need paragraph 1013 and the agricultural exemption in order to make this work, because short-term, restrictions of competition are necessary to make this transition work. Thank you.
Great, thanks, Martin. Just on interesting, so building on this interesting example, I mean, and kind of moving back to the US, I mean, how do you assess internally, in a sense, you have finite amount of people and resources, so you can either go for it on specific cases and enforce, and that's obviously a big production, and that's in a sense your bread and butter and your core mission. But also you can use a lot of the thinking within the agency to help other parts of government either advocate to lawmakers or potentially even more effectively work with other regulators to help them with the rulemaking. I mean, how are you doing this assessment at the moment? I mean, it's something in the CMA we always spend a lot of time thinking about, because at some level, enforcement you directly control. You decide what you do, you decide the timing of it, you decide the allocation of resources. Whenever you start partnering with others, obviously you lose control and you can lose more or less control. But at the same time, sometimes it can be much more effective to work with others rather than do a case yourself. So I suppose that's the kind of conversation you have all the time, but it's useful to get a flavor of your current thinking on that. Maybe Doha first and then Becca.
Sure. So we're really lucky at the Antitrust Division to have career staff who are expert on the industries that they police. And we work with a lot of other sister executive branch agencies. And I think I see Tim in the audience. It was Tim's terrific work to encourage President Biden to issue the competition executive order, which is really interesting because it specifically contemplated work among the federal agencies in the United States to pursue competition goals. One of the most interesting findings of that work is that Congress's design was not to make the DOJ and the FTC the sole enforcers of competition laws. In fact, competition statutes dot the entirety of the United States Code. There's the Packers and Stockyards Act, which is traditionally enforced by the USDA. The Department of Transportation is able to review mergers and unfair methods of competition. And what's very interesting about that statute is that it's actually modeled after Section 5 of the FTC Act, which prohibits unfair methods of competition and other kinds of business conduct. And the examples are myriad. Almost every agency has this kind of authority. And so recall also that we've had a conversation over the last several years in the United States about potential legislative updates to the law. And so that, plus the competition executive order, plus some of the forces that I was talking about earlier today, I think have provided really fertile ground for thinking about how competition enforcement can be better. And so setting aside the fact that we haven't been successful yet in getting legislative updates to the antitrust laws, we have become more creative about how to deploy different tools. And so I'll give you just a couple of highlights. We've executed a number of memoranda of understanding between the Department of Justice and other executive branch agencies to share information. Some of them contemplate delegation of authority. And so for the Europeans in the audience, which I think is most of you, in our constitutional structure, the Department of Justice, we are the lawyers for the executive branch. And so it is sort of contemplated that we are the chief litigators for the United States of America. And so other agencies can delegate their authority. Last summer, the U.S. Department of Agriculture actually delegated their Packers and Stockyards Act authority to the DOJ. And we filed a really significant information sharing case in the chicken processing industry, where we alleged that through a data consultant, several firms in the chicken industry had not only exchanged wage and benefit information, but that upstream, the chicken farmers were subject to something called the tournament system that actually deceived chicken farmers and deprived them of certain kinds of wages. And so I was heartened to hear Martin's story about all the chickens in the Netherlands, because we have a chicken problem in the United States. And so that's one example. I suspect you're going to see more examples of the DOJ working with other agencies to tackle competition problems.
And is that also a bit of a posture point as well for some of these agencies in terms of trying to, because I assume some of these things they haven't done for a while.
That's right.
So I guess that's so teams work and that work with administration to also try to change the posture of
Certainly.
some of these agencies.
Certainly. So I think these agencies have superpowers, right? In some cases, their authority is actually broader than the Sherman Act or the Clayton Act. And so working with our sister executive branch agencies to recognize their power, their duty, right, their congressional mandate to police competition in the sectors that they regulate in many instances is really, it's a highlight of our time, for sure.
Great. Thank you very much. Becca?
Yeah, I'd echo a lot of what Doha said and won't repeat it. The FTC is doing many similar things, working with other agencies to have memoranda of understanding, information sharing, and we do have a long tradition of weighing in on other agencies' approaches. The 2 points that I'd make to try to build on that are, I think, part of the really important work of the executive order was not just activating specific competition tools, but creating an awareness that the work of agencies affects competition, whether they do it knowingly or not. And if they are not paying attention to the effects on competition, they can exacerbate anti-competitive conditions or competition problems. And so I think of it as like an eye-opening exercise. It's not just utilizing tools, but being mindful of the ways in which the rules, the regulations, the work of other agencies affects the competitive conditions of the markets they serve. So that's one point. And then the second point I want to build on was Martin's really interesting conversation that Doha referenced about unfairness, because it is the case that the FTC statute particularly targets unfairness, and it does it in 2 ways. It prohibits unfair and deceptive acts and practices and unfair methods of competition. Unfair and deceptive acts and practices, well, unfairness, as Martin indicated, is a very broad term. What does that mean in practice? Congress has spelled out specifically for our unfair and deceptive acts and practices that for a practice to be unfair, it must cause substantial injury that's not reasonably avoidable and not offset by countervailing benefits. We don't have that same delineation of unfairness under our unfair methods of competition authority. And so for a long time, or not even for a long time, in the recent past, that was the Commission chose to interpret unfair methods of competition to mean basically like a pretty close to perfect overlap with what the Sherman Act already prohibited. But it is very difficult for me to look at statutory text that was passed after the Sherman Act that used different and broader terms and think that there is any fidelity to the statute in understanding it as meaning exactly the same thing. So what we have done is gone back and looked at the text, the structure, the history of the statute to say we are going to interpret, consistent with congressional intent, unfairness to be the broad term that Congress intended, and we'll pay the limitation on it is it has to be an unfair method of competition. It has to affect competition, be other than competition on the merits. That's the statutory limitation, but using that Section 5 authority is, I think, a really important way for us to build on the statutes that we are not just empowered to, but directed to enforce.
Yeah. Right, thank you, Becca. I just want to spend the last 5 minutes on the sort of labor issues on the European side. I must confess that the CMA always thought, we didn't really do anything during my tenure on labor, mainly because no one really came to us with questions. So I always wondered whether, we were just not looking hard enough. Benoit and Martin, have you done anything? I mean, have you received complaints about no poaching? I mean, obviously now we understand in the US there are very extensive no poach agreements, including a number of industries that you question why they should be there. I mean, is that something that has come to you in terms of complaints or issues in France and the Netherlands? I don't know, Benoit.
Yeah, we have a couple of cases that we are looking into, but I think it's fair to say that it's not it's not a big issue. It's not as widespread as in the US. Well, might be also the result of labor law being so so broad and developed and intricate in France that probably there is not much room to do for antitrust to do anything in that field. It's a kind of it's the kind of places where you have this post saying the sheriff is not welcome. A little bit like farming, because it's already so regulated. Prices are regulated, quantities are regulated. So what can you do?
Yeah, thank you, Martin.
Yeah, we've been quite relatively active in, I would say, on labor. In 2019, we issued new guidelines on horizontal cooperation and horizontal kind of prohibitive behavior, including labor restrictions. So there we made it in our policy papers for the first time. We made it clear that collusion on wages and labor conditions were kind of illegal, including non-poach agreements or practices. And since then, we kept it relatively low in the sense that we did not make this into high-profile cases, because I thought we need also, the markets need to understand that this is illegal. And we also talked to the unions quite elaborately that, when I did my tour, when I joined the office in 2018, I went to the unions and they said, well, what are you doing here? We're not interested in antitrust because antitrust is for businesses, not for us. And then I explained that it's also for them. And that was an eye-opener. And now we have unions very active, looking out for illegal wage agreements and non-poach agreements, and also tipping us off with cases. We're also now slowly applying labor issues in merger control, particularly with regard to non-employed or self-employed workers, but also to employees. So far, we've tested theories of harm only in journalism and in media. But we're not able to prove it, or that sounds like it was there. But we tested the theory, and there was no evidence for the theory. But nevertheless, it is part of our merger control policy also to look at labor issues.
Thanks. So Benoit, let's come back, and then Margarita, I'll give you the last word.
Yeah, just wanted to add that I have exactly the same experience with trade unions. But some workers are also companies, right? And platform workers are a case in point. So in the context of the discussion on the European directive on platform workers, we've been involved because there you have an obvious competition dimension.
Yeah. So Margarita, last word. It would be useful to get a bit more flavor of your cases and your actual activity on no poach, just again to get a sense of the sectors. I mean, to the extent you can talk about it.
Okay, well, maybe I should just take a step back and say that what really helped us in building the pipeline for what we were certain that was happening in terms of infringement in labor markets was a guide that we wrote for firms, basically on the do's and don'ts in labor markets and what you shouldn't be doing as a firm in terms of no poach agreements or other horizontal agreements with other firms, and that was very eye-opening for many employees who came forward with tip-offs and to firms themselves as well who came forward with leniency requests, some of them. What I can say now is that this is not something just limited to a very specific category of workers. This can be something that is actually quite wide-ranging in a specific sector. So, for example, in the SO that we issued last November in the health sector, this concerned everyone in the labs sector, from the technical staff that conducted the tests and analyzed the the blood tests and others, but also, it came down even to the assistants and the receptionists. So it can be quite wide-ranging. Of course, there are areas that are probably more prone to this type of agreement, areas in high demand, such as the IT sector, for example. But this can be quite wide-ranging from what our experience has shown us.
Great. Well, thank you very much. Thanks, everyone. It's been a very interesting discussion. Please help me thank the panel.